Thank you, Kelly. Welcome to the first meeting of the Travel, Recreation, Wildlife, and Cultural Resources Committee. First of all, I would like to introduce our new, she's our new VIP, Kelly Lower. She's from the LSO, and she'll be with the TRW committee throughout. So we're excited to have her. And welcome to the rest of you in the room. And we're just excited that there's a few folks here. And again, this is the fun committee, so we'll have some fun and enjoy ourselves, I'm sure. I'm supposed to read an opening script. I'm really not going to read this opening script because we're supposed to talk about our rules of decorum. I'll just mention that please, direct your comments to the chair and make sure that you avoid personalities and comments of a personal nature if you can. And again, just be nice. That's really pretty much what I say all the time is be nice. And I think we'll get along just fine, be professional. So with that, we'll go ahead and start with roll call.
Senator Baldwin.
Here.
Senator Ellis.
Present.
Senator Garou.
Excused?
Senator Jones. Chairwoman Schuler.
Here.
Madam Chairman, you have a quorum.
Thank you. All right, we're going to begin this morning with Senate File 18, the Indian Child Welfare Act Safe Haven Amendments. This was sponsored by our Select Committee on Travel Relations, and I think they popped out a couple of really good bills. And so we're going to turn the time over to the chairman of that committee, Senator Ellis.
Madam Chair, would you like me here or at the dais? Do my colleagues have a preference? Okay. Well, thank you, committee members. I want to first start off by saying thanks for hearing this bill. And just so for the folks watching and maybe aren't familiar with our protocol, these bills could have easily been referred to other committees. I think Department of Family Services doesn't normally come to TRW, but because it could have been referred to the Labor Committee chairman, and they've got a lot of bills. And so TRW had some time and availability. So I just want to make it clear, like sometimes our committees step in to subject matters that maybe they're not always as familiar with. So this is not unusual. We also have some interns in the audience, and so I want to explain a little bit about what the Indian Child Welfare Act is so that it provides some context for why these bills came about. For a lot of years, Native children were being adopted out en masse to non-Indian families. And this was particularly prevalent throughout the 1950s and 60s. And so it wasn't until 1978, though, that the US Congress said no more. In an effort to try and preserve Indian families and Indian tribes, Congress passed the Indian Child Welfare Act, or ICWA, as we like to say, and it requires some procedural things. So if there's a Native child involved in a state court proceeding that might result in that Indian child being removed from their Native family, that the tribe receives notification and a right to intervene and some other safeguards. Since that time, there have been some conflicts between states and tribes, but I'm very proud of the fact that I think our Wyoming Department of Family Services, our Wyoming courts really have tried to adhere to the spirit of ICWA. However, several years ago, there were some challenges made to it because, as I mentioned, there tends to be some conflict, and those conflicts usually arise when people just don't like the act and don't want to follow it. So there were a number of cases that came before the US Supreme Court, and there was concern that the court might strike down ICWA in its entirety. One of the arguments that was made by the people challenging the act was that Congress overreached. Matters like this that involve delegation of parental rights or termination of parental rights are usually left up to the states to manage. So if that were the case and ICWA was struck down, we wanted to make sure that we had a seamless process so that we could adopt all the provisions and protections contained in ICWA in state law and things could continue on. So that's the bill we passed last year. We also created a task force to Wyomingize or make ICWA work better for Wyoming according to our laws. And it was intended to be a deep dive into some opportunities there. However, the US Supreme Court upheld ICWA in its entirety. So this need for this task force really, we didn't have to do as deep of a dive because by and large, we're just going to still comply with the federal law. However, we did identify two areas, and that's what you're going to see before you, Senate File 18 and Senate File 37, which fine-tune our state statutes to comply with ICWA. So the first one has to do with safe havens. And safe havens are our state's recognition that there might be people who are struggling to raise infants and children. And so what happens if we don't want to encourage these families to do, things that might harm those kids. We want to encourage them, if they want, to take them to a police station or a fire station so that they can receive care, and ultimately we'll find placement for them within our state system. So those are called your safe haven providers. When a safe haven provider receives a child, our statutes indicates, how about you ask for some important information? Any identifying information, medical history. That way, if the child is, an infant and the person relinquishing the child knows that they have a medical condition, they don't have to discover it before it's too late or there's harm to the child. So our statute contains some language like that. So what we're asking for and trying to do in this bill is to also say, if you're a safe haven provider, like a police station or a fire department, that when you're receiving a child, you ask, do you know if this child has any tribal affiliation? If that's the case, then they can contact the child, and Director Schmidt from the Department of Family Services can answer questions about what happens after that, but there's a process in place. I would offer anecdotally that in my experience, sometimes tribes are notified and they don't always want to be engaged in these court proceedings. I think what the problem arises, though, and when you see, court cases like the ones that led to the challenge in the US Supreme Court, are when states really dig in their heels and say, we don't want to comply with ICWA. Then the tribe's notified after the fact, and then it becomes more of a preservation of sovereignty and following the act. So I think it's better for the states, I think it's better for tribes, and it's better for children ultimately when tribes are notified early on in the process. So that's what Senate File 18 does. It says that if you're a safe haven provider, you have to ask about whether or not the person knows if they have Native American ancestry. Along those lines, on page 2, lines 9 through 16, that's just a conforming amendment. And then the rest of it is the enactment clause. It would allow the Department of Family Services to immediately begin the rulemaking, but the requirement wouldn't take effect until July 1st. So I know that was a long explanation for people who have lived it and have been along for the ride, but I just wanted to provide some information for some of the interns and aides that we have in the audience. Happy to answer questions.
Any questions, committee? I just have one, actually a couple. Were there issues with changing some of the verbiage from may to shall? Do you felt like that was probably making the bill a much stronger bill? And I know we had may on the first page, the parent or parents designated may provide information, but then on the back, it just basically says that the provider shall ask the parent. Was there any issues or a lot of discussion on that?
Thank you, Madam Chair. We did have some discussion on that, and at the end of the day, we felt that it was important to make it a shall. And the way this is just a grammatical thing, the way the paragraph actually read initially, we had to wordsmith some of it to just kind of clean up the language to make it sound appropriate. So that's what this is intended to do, is strengthen it a little bit, but also some of the mays to shall didn't work because of the language that you'll find on page 1 at the first part, lines 13 through 16. So we had to smush it in there and it just read better. And obviously we made a policy choice there.
Thank you for that. And just to follow up, I don't know if this, I assume this has probably happened in the past. Has there been an issue with some of the tribes, again, not wanting to give the information, or they prefer to give the information so that, the ancestral background is known?
Thank you, Madam Chair. So this doesn't affect the tribe. This just really affects the person who's delivering the child to a safe haven provider, and then the duties on the safe haven provider to ask the question, do you know if this child has information or not? We left it open-ended. Certainly the person handing over the child could say yes, no, or I don't know. So those are all acceptable answers. But if they say yes, I think that, mom is a certain tribal affiliation, then at least that triggers the ability to contact that tribe and see if they have any information about who that child might be and whether or not they want to be involved in the state court proceeding.
Other questions, committee? Okay, thank you for that. In that case, we'll go ahead and open it up for public testimony. Anyone that would like to testify on this bill, please come forward, introduce yourself. Come on up. There's safety in numbers, so this is good. Please introduce yourselves, please, for the committee. Yeah, just push the green button.
Okay. Chairwoman Scholler, my name's Anita Roman. I'm Tribal Liaison for the Northern Arapaho Tribe under Governor Mark Gordon. I just wanted to, do we all introduce? Sorry.
I don't have a green light.
Sometimes you have to push a couple of times.
Oh,
Get there.
oh, there it is. Chairman Schuler, my name is, committee, my name is James Sarles. I'm the Eastern Shoshone Tribal Liaison at Governor Mark Gordon's office. Thank you.
And sometimes you have to just have one at a time that shows green, otherwise it'll kind of mess up things. So just for the reference. Go ahead.
Chairman Schuler, Kate Wentland, Special Counsel, Tribal Relations, Policy Advisor for Governor Gordon, and just here in a support role today.
Go ahead. We're excited to hear from you.
Really, while I can't speak directly for the Northern Arapaho Tribe, I know that our tribe really helped work on this bill. Chairwoman returns to war and the lawyer. So there was a lot of collaboration, and I just wanted to voice my support for this bill.
Thank you.
Chairwoman Schuler, whoops, I'm gonna back up a little bit. Yes, the Shoshone Tribe, I know had a couple of members that were also on the task force. I think Councilman Large and another I think Sarah Robinson, I think had some stuff and input. But like she said, I cannot speak for them. But the governor does defer to the good work done by the ICWA task force, and in the process it did. He supports this bill. That's about all I have on that so far. Thank you.
Thank you. Mr. Wentland, would you have any interest in testifying?
I'll join the party, Chairwoman Schuler. Yeah, just to summarize, good work done by the ICWA task force, substantial involvement by both tribes, and the governor supports this bill moving forward. ICWA was important for the state, and making sure it functions well moving forward is important as well. Thank you.
Questions from the committee for anyone? I just have one. Are you, everyone comfortable with the verbiage and with everything, the way the bill is right now? We are. Okay. Thank you.
Madam Chair?
Yes, go ahead.
Madam Chair, along those lines, I think we'll get questions on the floor about the may versus shall. So if you would, do you think they shall ask rather than they may ask is appropriate?
Go ahead.
I actually do think shall, or Chairwoman Schuler, I apologize. I do think that shall is important verbiage.
Chairman Schuler, Senator Ellis, I also believe that shall kind of gives them a little bit of push, so may say. Thank you.
Follow up? Okay, great. If there's no other questions, we thank you for taking the time to come down and testify on this bill. Appreciate all your words of support. So thank you very much. Anyone else in the room that would like to testify on this bill? Welcome, Director. Even though we know who you are, you still might want to introduce yourself for the Zoom folks.
Thank you, Madam Chairwoman. My name is Corin Schmidt. I'm the Director of the Wyoming Department of Family Services, and thanks for hearing this bill, and it's a pleasure to be in front of you. I really don't have much to say about the substance of the bill. I mean, of course, we think it's really important. I do want to point out, though, that there is another piece of legislation that I don't know if it's been introduced, but it's certainly on the docket about extending the safe haven days from 14 to 60, I believe, and I'm going off the top of my head. And all of that is to say is that with this bill, and if that other bill passes, we'll be doing quite a bit of education around safe haven. It's not something that we use all that often. We do not, I think over the past 10 years or so, have maybe had 5 or 6 children who we've received custody of as a part of safe haven. But I do think the conversation around this and potentially the other piece of legislation will then help us to start a little bit more of a public information campaign with those people who are providers or who are eligible to receive children law enforcement, fire, et cetera. So with that, then, will be the opportunity also to talk about asking this question and why this question is important. So just as you move forward, maybe having that kind of in the back of your head.
Questions? Yes, go ahead.
Thank you.
Senator Ellis.
Thank you, Madam Chair. Just to refresh my recollection, law enforcement and fire departments always stick in my mind as being safe haven providers. But if we get asked on the floor, are there other examples of providers? I just want to make sure we're prepared or I'm prepared.
Director?
Madam Chairwoman, Senator Ellis will get you that list. I don't have it off the top of my head. I think DFS is one of those agencies, but we'll verify that for you and get you an email. Sure.
Other questions for Director Schmidt? Just you started to talk about they may expand the number of days. Director, what, from 14 days to?
Madam Chairwoman, to 60 days, I believe.
60 days.
Yeah.
Wow. Any other questions? Okay, well, thank you for taking the time to come see us.
Yeah,
We don't get
thank
to
you.
see you very often.
I know, it's nice. Thank you.
We are the best committee. Yeah, it's true. We are the
It's
best.
actually been my pleasure. This has been very enjoyable, so thank you.
We always have fun. It's very lighthearted, and there's not a lot of, gnashing of teeth here. So,
Madam Chairwoman, I always used to tease Director Westby that he was all about rainbows and unicorns, so I'm sure you are as well, so thanks.
yes, we probably need some of those as well. Thanks so much. Anyone else that would like to testify on this bill? Welcome, Travis. Introduce yourself, even though we know you, some of us.
Thank you, Chairwoman Schuler. My name is Travis McNiven on behalf of the Northern Apple Business Council. Before I testify, I did want to just see if Karen Returns Tour was able to make it onto the Zoom she was trying to get available. Okay, and so if she's on this morning, I would like to go to her at this
Sure.
point, if that's okay.
Sure, we can do that.
Karen Returns Tour, if you would turn on your mic.
Welcome. Introduce yourself, please, and we'd love to hear from you.
Dosnianka. Na Dilkuse. Nanana. Basawunina. Niente Jana Antana. So what I basically said was I introduced myself in my Arapaho name. I said, good morning. I said, hello, good morning. My Arapaho name is Sitting Woman. My English name is Karen Returns to War. I come from the largest clan of the Arapaho people, Hinane Eitan. And I said that I am glad to be here. I would just like, first of all, Chairwoman, and the rest of the committee, I would like to thank each and every one of you for allowing us this time and to express how important this piece of legislation is to our Arapaho people, our Arapaho families. And I am not being radical or disrespectful in anything that I'm going to say. I just would like to reiterate a comment that was made back to the United Nations back in 2020. There was a comment made said that ethnic cleansing is a systematic forced removal of ethnic, racial, or religious groups from a given area with the intent of making a region ethnically homogeneous, along with direct removal, extermination, deportation, and population transfer. It also includes indirect methods aimed at forced migration by coercing the victim group to flee and preventing its return, such as murder, rape, and property destruction. It constitutes a crime against humanity. And I would just like to add to that and say that a lot of back in Senator Ellis had stated, back in the 1950s and 60s, it was common practice for BIA social workers to encourage the adoption procedure. And that was the policies of the United States government to the First Nation people of this country, of these countries, this land base. And so we in turn are trying to go back, because of all this in the boarding school era, removing the children from the family, from the influence, and teaching the traditions and the ceremonies and hearing the language. We are in turn now trying to come back and regain our language. We are really strong in that effort. I myself was fortunate, well, my personal story is that because of those policies, it was okay. It was encouraged. My mother and father had a total of 11 children combined. And so it was one of her cousins, one of my uncles had approached him and asked to take, help them along with one of their own children. So I was adopted by my uncle from up to the age of 7. And then I returned back to my original family, which I am grateful for, because in those times we left the reservation, we lived in Nebraska, and we lived in New Mexico, down in the Four Corners area. It was difficult. It was difficult for me because I was different from other children. And so I had to learn firsthand what it was to be discriminated against and bullied because of the color of my skin. And also my uncle's family and children were always light complected. And as you can see, I'm not, I'm dark complected. And so I dealt with those issues early on, but I was so fortunate to be allowed to come back to my people and my own family. I am very strong in my culture, my traditions. I was raised around, I heard our language all the time. However, because of the boarding school area, our parents did not think it was wise to teach us. They wanted us to learn the English language first and foremost so that we could benefit. And that they were always beaten for speaking their language, and they didn't want any of us to experience all that stuff. So our generation was not immersed in the language. We heard it, but we didn't have it. We didn't conversate daily with it. And so a lot of us are coming back and relearning the language. So I'm proud to introduce myself in our native language, because that's who I am. That's what makes me different from any other race, any other person, any other tribal nation. Is my language, my Arapaho language. I believe I would like to commend the Tribal Select Committee, the ICWA Task Force, everybody involved in this endeavor. It has been great working with each and every one of you, and I'm hoping that after this testimony that everything's going to fall into place, and that our tribal people, our tribal families, and our tribal children will continue to grow and be who we are, because we are individuals. We're, each and every one of us, we have roots back to, I'm sure you have roots, and you guys, everybody has their own culture and taboos and language, and I believe that all of us should embrace that. Thank you for having me. Ho. Thank you.
Thank you so much, Karen. Returns to where I first of all, I just loved hearing your language, and I'm so glad that that part of your, your tribe, you've kept that. It was beautiful to hear, and I hope you continue to pass that down to the next generation, and so on and so forth. I think that's so important. And unfortunately, I feel very sorry that our government in the past they've done some things that are certainly reprehensible. And I would apologize, even though, I know that we're moving forward from that. But are you feeling fairly comfortable with this bill as it is?
I am. We have spoken in great lengths, and we had several discussions with DFS, with the Safe Haven people, and all our task force members. So I am comfortable with it.
Thank you. Other questions from the committee? Thank you again for taking the time, and thank you so much for your testimony and that little bit of history, just to remind us of where we were and where we've come and how hopefully we can move forward. So thank you so much.
You're welcome. Have a good day.
Yeah, thank you. Have a good day. Anything else you'd like to add?
Thank you, Chairwoman. Only two very, very short things. One point on the shall, of course, that is just on the asking. That is not requiring, the answer side of that there's, certainly discretion on that side of that, shall or may, point. And then the other thing that I was going to ask or going to say, just for the benefit of the committee, I did look that up. That is House Bill 90. That is moving the infant from 14 days to 60 days, and that has been introduced and referred to committee at this point, and so did pass introduction there in the House.
Thanks for that information. Questions again for Mr. McNiven? Okay.
Thank
Thanks
you.
so much for coming. Appreciate it. Is there any other public testimony from anyone in the room? Or is that the only person we had online? Zoom? Going. Okay, looks like we're good. All right, with that, we'll close public testimony. Committee, what's your?
The bill.
Okay. Second. Okay. Had a motion from Senator Ellis to move the bill, a second from Senator Baldwin. You see any changes or amendments or anything that you'd like to change or fix? Questions been called on the bill? Let's take roll on it then.
Senate File 18, Indian Child Welfare Act, Safe Haven Amendments. Senator Baldwin.
Aye.
Senator Ellis.
Aye.
Senator Guru.
Excused?
Senator Jones. Chairwoman Schuler.
Aye.
4 ayes, 1 excused.
Okay. Thank you very much. I think Senator Ellis will carry this on the floor. She's, at least right now, she said she is, so hopefully she's not going to get sick on us.
There's always that.
There's always that. All right, we'll move on to the next bill, Senate File 37, Indian Child Welfare Act Delinquency Amendments, and Senator Ellis will present this as well.
Thank you, Madam Chair. So as I mentioned in presenting the other bill, the Indian Child Welfare Act applies whenever you have a situation that could result in termination of parental rights, or TPRs. And this, as Ms. Councilwoman Returns to War indicated, this is because, we saw a lot of Native children. The presumption was that they would have better opportunity if they were adopted out of their tribe, if they were, placed with white families. So that was the intent of ICWA. However, each state does ICWA a little different, and we have a unique relationship in Wyoming with our tribes. Our Department of Family Services, we have the 2 tribes on the Wind River Reservation. So there are also other actions that are looped up in our family statutes that regulate family matters, and one of them are delinquency petitions. And so this is when you have a juvenile who's a delinquent and gets kind of wrapped up in that system. In those cases in Wyoming, our Department of Family Services has agreements where they reach out to our tribes. That delinquency action, though, is not included in the federal ICWA. So we included it when we codified ICWA, but it is inconsistent with federal law, and it's creating some confusion out there. So the example would be if you have a tribe or a child whose tribal affiliation isn't in Wyoming, Department of Family Services can speak to this more, but they're reaching out to these tribes, and the tribes are like, why are you calling us? This is weird. What are we supposed to do? And so Department of Family Services asked that we remove the delinquency petition from our statutes, but I'll let the department explain a little bit more how it works when they talk to our tribes directly. The other reason I think it's important for us to address this issue, I was asked by our Children's Justice Project, and I think I see someone from the courts. They look at a variety of issues, and so they asked me to come provide an update of the state codification of ICWA, and this was an issue that was raised to me as well, is what do we do with this? So it's creating confusion. We already have workarounds of how we work directly with our tribes on these matters, and so this would just remove the delinquency petition from triggering some of the ICWA notices requirements to other tribes. With that, I'm happy to answer any questions, but I can tell you Director Schmidt knows a lot more about this than I do.
Any questions for Senator Ellis before we move on? Okay. Director, would you like to come and give us a little more information on this? Welcome back.
Thank you, Madam Chairwoman. To Senator Ellis's kind of point, this gets a little bit confusing and in the weeds, so I'll try to keep it high level, but please know I'm more than willing to answer any more questions. In our state, we do have a provision that includes juvenile delinquents in the work that DFS does. In a lot of other states, those juvenile delinquents are heard through a different system. So it might be an adult court system, it may be through an adult corrections type system. But our state a long time ago made the decision that if there's been a petition filed in juvenile court with a delinquent, the definition of a juvenile delinquent under the Title 14 statutes is a child that has committed a crime. So there has been a crime involved, but the county attorney has the discretion to look at that crime and say this child will be better served in a juvenile court environment and will file a petition in juvenile court. So it comes back to discretion about how to best serve that child. When a juvenile delinquent then does come into juvenile court and it's under the purview of the Department of Family Services to provide services, we provide a lot of intensive services. And that isn't typical in a lot of juvenile justice systems in other states. But that's why when the codification occurred of the federal law into state law, that's why delinquents got picked up. In other states, they wouldn't get picked up in that type of codification. So when we have an Indian child who commits a crime and there's a petition filed in juvenile court, we're now compelled to follow ICWA. So we will contact the tribe. If that child is affiliated with the tribe, we would contact that tribe and say, do you want to take jurisdiction? In other states, they don't have the structure necessarily to take jurisdiction of that child under ICWA because it's something that we've created in Wyoming only. So it creates a lot of confusion just in terms of process. And one of our concerns from that would be is that a child gets stuck in a system while the bureaucrats try to figure out how to get a child transfer. And then as a result, that child can be just sitting waiting for everyone to kind of understand what the process would be. In addition to that, some of the testimony early on at the ICWA task force was concerned about jurisdiction around criminal offenses and are those transferable. So again, the child came in with a crime, there was a crime committed, and is that a transferable, and this is getting way out of my wheelhouse in terms of legal stuff, but that was something that one of the ICWA task force members had brought up. So it just kind of put everything into question and kind of made it all very confusing. So to do just a little bit of a cleanup, I think will help to get the system back to where it has typically worked. To Senator Ellis's point about our contracts. So this may be just helpful context for any conversations that you may have to have on the floor. The legislature appropriates to the department funding for both tribal DFS offices. So in our budget, you see a division budget solely for tribes. Those dollars that we receive from the legislature, we give to both tribal councils separately in contracts. And in those contracts, then both tribal councils have local DFS offices, Eastern Shoshone DFS and Northern Arapaho DFS. And it's through those offices that they do the work of child welfare, children in need of supervision, adult protective services, and juvenile services. In that contractual arrangement that we have with both tribal business councils, and this has been a long-standing relationship, what we have are provisions in that contract for Hot Springs County and Fremont County, where the tribal DFS offices can come and work directly with tribal families or members off reservation. So if there's a family that has allegations of abuse and neglect, and we know that they're affiliated with either Eastern Shoshone or Northern Arapaho, then law enforcement can call one of those DFS offices, that DFS office will respond, and then that case can be moved into tribal court. What that actually is ICWA without a lot of other steps. So it's just been a happenstance that this has been the relationship that's been formed for many, many years. And really what it does is it expedites ICWA. So instead of having to go back to a district court, we just instead work together, and then the tribal court can take jurisdiction of those abuse and neglect cases. And then we're not concerned about having to contact the tribes and making sure that we've followed all of the ICWA requirements. Those decisions are made on the spot. So it gets confusing because of the way that we, our relationship with both tribal DFS offices through that contract. It is pretty atypical, really, in terms of state and tribal relationships throughout the US. I think we take great pride in that contract and that relationship, because I do think it really does, at its very core, honor what ICWA is trying to achieve. But it does make it a little bit different in terms of tribal DFS, state DFS, child welfare relations.
Questions for Director Schmidt? Just one. So basically, hopefully this change should really streamline the whole system and really help our folks get a little bit services quicker. Is that what I'm understanding?
Yes, Madam Chairwoman, if a child is a delinquent and is an Indian child, we would just continue as we would with any child in that situation for that delinquency. So we can provide the full array of services that we would give to any child in Wyoming. So it really does, for that child, streamline it.
Any other questions, Senator Mills? Okay, great. Thanks again for your
All right.
testimony.
Yeah, thank
Appreciate
you.
it. Anyone else in the room that would like to provide testimony? Welcome. Even though we know you, I know you from another committee. Please introduce yourself.
Good morning, Madam Chairwoman, members of the committee. My name is Elisa Butler, and I'm the State Court Administrator for the Wyoming Judicial Branch. I just wanted to get up today and let you know that the judiciary is in full support of this bill. It is causing some confusion right now, the way the statutes read, because there is a little bit of a conflict. And as I would just echo what Senator Ellis and Director Schmidt just told you, it historically, this has not been the practice, at least statutorily. In many of the district courts where they do have delinquencies that involve Native children, they will notify the tribes just to, do their due diligence, make sure the tribes know that these kids are in their courts. And so that's just a practice that most of our district courts do today, but statutorily it has never been a requirement. And it is, I think, creating some confusion, some delay. And so we would just support this cleanup that would, reduce the delay for kids who come into our courts.
Questions for Ms. Butler? Thank you again for taking
Thank
time.
you.
You probably never get to come here to this committee very often, huh?
It's a nice committee.
Yeah, it is. We're the fun group. Anyone else in the room? Yes, please, come on up. Welcome back.
Here we go again. Chairman Schuler, committee. Again, I'm James Charles. I'm the Shoshone Tribal Liaison. Again, let me reiterate, the governor does defer. This has been a good collaborative job, good work, great work. He supports this bill again, and again, I can't speak for the tribe, but this bill did come out of some collaboration with them, so it is a good thing moving forward. Thank you.
Thank you.
Chairwoman Schuler, committee, Anita Roman, tribal liaison for the Northern Arapaho tribe. So again, I wanted to support as I work with Governor Mark Gordon's office, I understand that he definitely supports this bill and does defer to the ICWA task force and the good work that they've done. So the Northern Arapaho tribe is also, they've done a lot of work with this. I was very proud of Chairwoman Returns to our getting on and speaking on behalf of the work that's been done.
Any questions for either one of our tribal liaisons? Okay, Thanks again for being here and for taking the time. Appreciate the support too on this bill. It helps to know that the governor's office and you folks are in support. So thank you so much. Anyone else? Welcome back.
Thank you, Chairwoman. Travis McNevin, again, on behalf of the Northern Rapids Business Council, standing in support of fully supportive of the bill. Councilwoman Returns Store sent me a message and said, thank you, but had nothing to add at this point for that, and that the council does support the bill, and deleting those words and cleaning things up a little bit to make things a little easier for the process there. Thank you.
Any questions for Travis? Okay, thanks so much. Appreciate your support. Anyone else in the room? All right, anyone online for this one? Other than, no? Okay, great.
Madam Chair?
Yes.
Just I wanted to clarify, so Section 1 amends the session laws that we adopted last year. Section 2 is the actual repealer of 146201D. This bill could just be that, but we thought belt and suspenders to make sure it was clear to amend the session law.
That's good information. So,
The only other thing I'd add, Madam Chair, is, we have this being effective July 1st. I think that that's probably appropriate, but we certainly, if you felt compelled, change it to effective immediately.
good.
Something to think about.
All right. Well, with that, we'll go ahead and close public testimony and committee. What's your pleasure? Move the bill. Senator Ellis. Second by Senator Jones. Would you like to go ahead and make that amendment, or do you have anything else that you'd like to add, Senator?
No, Madam Chair, I move to amend page 2, line 6, to make the bill effective immediately.
Okay. Do I have a second? Second. Okay. All right. Any discussion on that? All right. I think that's a good catch. All those in favor of that amendment, please say aye.
Aye.
Any opposed? Okay, by the same, that passes. Kelly, did you get that? All right, it's an easy catch. Anything else on the bill you'd like to amend? Okay, question's been called. Please take roll.
Senate File 37, Indian Child Welfare Act Delinquency Amendments as amended. Senator Baldwin.
Aye.
Senator Ellis.
Aye.
Senator Garou.
Excused?
Senator Jones. Chairwoman Schuler.
Aye.
4 ayes, 1 excused.
Okay, the bill has passed, and again, Senator Ellis, will you carry that? Appreciate that. Thanks, everyone, for coming. I think these are both great bills, and hopefully we can get them over the finish line and make things better for our folks up there. So unless there's anything else, we'll go ahead and adjourn. Thanks.